Okay, hello. Welcome to another event of the Center for Constitutions in Context, or CCC for short, here at Warwick Law School. I am David Vitale, Associate Professor at Warwick and co-director of the CCC. And joining me is my co-director and colleague, Mara Malakodi. So we are absolutely thrilled to host today's event, which is, I think, a first of its kind in our field of constitutional law. It's a discussion on contextual approaches to constitutional law, specifically in academic publishing. And to this end, what we've done is we've brought together representatives from six different or leading comparative constitutional law journals. So kind of to get right to it, I'll briefly introduce our wonderful panel of speakers. Okay. So first, moderating our discussion will be, we have Tom Ginsburg. Tom is Leo Spitz Distinguished Service Professor of International Law, as well as Professor of Political Science, University of Chicago. Next, representing the journal Comparative Constitutional Studies, we have Lulu Weis, Associate Professor of Law, University of Melbourne. Representing the journal Constitutional Studies, we have José María Serna de la Garza, researcher at the Institute of Legal Research and Professor of Law, National University of Mexico. From European Constitutional Law Review, or EU Const, we have Monica Claes, Professor of European and Comparative Constitutional Law, University of Maastricht, as well as Leonard Besselink, Professor Emeritus and former Chair of Constitutional Law, University of Amsterdam. From Global Constitutionalism, we have Susan Kang, Associate Professor of Political Science, John Jay College of Criminal Justice, City University of New York. From the International Journal of Constitutional Law, or ICON, we have Gráinne de Búrca, Professor of Law, European University Institute, on leave from her position as the Florence Ellenwood Allen Professor of Law, New York University. And last, but certainly not least, representing public law, we have Aileen McHarg, Professor of Public Law and Human Rights, University of Durham, and Roger Masterman, Professor of Constitutional Law, University of Durham. So with those brief introductions, just a few quick points about how the roundtable will run. So moderated by Tom, our presenters will be responding to a series of 5 questions that we've pre-circulated to them. And they all center, of course, on today's topic of contextual approaches to constitutional law in academic publishing. If there's time at the end, and we hope to have a few minutes at least, we'll also be taking a few questions from the audience. Therefore, if you have a question that you would like to ask our panel, please pop it into the Q&A section of Teams, and we'll, as always, do our best to collate and convey as many as time allows. Please note, that in choosing kind of questions to convey, I'll try to focus on questions that are relevant to a broad audience and that don't repeat or overlap too much with what has already been discussed. And so, as not to delay our discussion, I'll turn things over to Tom.
Thanks so much for having us all here. I'm looking forward to the discussion. This idea of contextual approaches to comparative constitutional law is something we're starting to see. Of course, the name of the center hosting this very discussion is one example. David Law's book, Constitutionalism in Context, the edited volume with many contributions from lots of people trying to take that approach. Hart's Constitutional Systems of the World. I think I want to start with the question of what this means to you all. What exactly is a contextual approach? How is it different from a non-contextual approach or a traditional approach or another kind of interdisciplinary approach that one might take? So let's start with that question. And I think what I'll do is I'll just call on you because in the order in which I see you on my little screen. So I'll start with you, Aileen.
Thank you. Can you hear me?
Yes.
Okay, thanks. So it's good to have the difficult question first. So Roger and I were talking about what this means to us, and I think we kind of defined contextual approaches fairly loosely. So, you know, as something that is not purely concerned with legal doctrine, or purely kind of theoretical or contextual issues, but conceptual issues, but rather is interested in situating the law or the constitutional rules in their context, whether that's social context, political context, economic context, whatever. So asking questions, you know, like how does the law operate in practice? What are the factors that have influenced the development of the law? They might be concerned with law reform issues, or they might be concerned with, and this is maybe a particular feature of UK constitutional law, they might be concerned with the bits of the Constitution that are not regulated by legal rules or solely by legal rules, and therefore where you know, in order to understand what the rules are and how they operate, you have no choice but to look at their practical context.
That's very helpful. Monica, how about you? Do you have anything to add?
Well, very much along the same lines. So to me, a law in context approach is usually an approach whereby you look beyond the law and you put the law in its broader context. I think that what is important to note is also that it mostly relates to the type of questions that are asked about the law. So whereby I think questions are asked that the more traditional doctrinal approaches cannot answer. So the questions would relate to issues like, why is the law as it is? Or how does the law really work in practice? What is the impact that the law has on society? Does it affect society, economy, or what have you? Or also questions of what should the law really be like? So much more normative approaches. So all, I think, types of questions that a doctrinal approach is not able to answer sufficiently.
Mm-hmm. Yeah, that's very
In
helpful.
addition, I would say, so if I may, adding from the perspective of our journals, or the European Constitutional Law Review, in our journal, all of this is also approached in a specific geographic context, right? So we are a journal of constitutional law in a European context. Questions can be questions of comparative constitutional law, of European law, both EU law, law of the Council of Europe, but putting it in a European context.
Thank you. You know, I think what I'll do is invite people to chime in rather than go sequentially through everybody. Is there anything, but maybe just to kick things off, despite what I just said, I will turn to José María, who's in light of Monica's point about the European focus. Is there anything different in the way this might be understood in your part of the world, José María?
Well, in principle, I agree with what Monica and Aileen have said. To me, contextual approaches to constitutional law implies recognizing the importance of historical background to understand constitutional law developments. It also implies considering social and political environment, the social and political factors that influence constitutional law, constitutional design, constitutional interpretation, and also recognizing that constitutional meanings can evolve in different ways over time in response to changing social developments or changing social values. I can also mention my experience when I wrote the book on Mexican constitutional law in context within the Hart's collection of constitutional systems of the world. In the case of Mexico, and I would say in the case of most Latin American countries, a contextual approach implies making a, let's say, a comparison between constitutional law on the books and constitutional law in actual practice. There is a difference in many of our countries in what the Constitution says and what actually happens in political life. And this has to do with the political practices, political culture, the constitutional culture, and this, of course, implies a contextual analysis.
So this strikes me as so far where we've gotten is essentially a kind of law and society or interdisciplinary approach that's a non-formalist. We're defined by being non-doctrinal and such. I wonder if anyone else has anything to add to supplement that or take issue with it.
I kind of wanted to add something really quickly, which is that I think there is a stream of thinking within comparative constitutional law that sort of large and statistical studies can be useful. And I think that what a contextual approach sort of thinks in terms of these like more statistical large end studies is that there needs to be recognition that constitutional norms are very different in different contexts, whether it's national or even historical, right? Particular constitutional norms and protections will mean different things and have different effects at different periods of time, even within the same national context.
Yes, excellent point. Any other comments?
Maybe I'll
Gráinne.
just jump in briefly, Tom. Yeah, just to say, I mean, a lot has already been said, but when I first saw the question, my first instinct was, wow, what's not law and context? So law and context became a thing decades ago, and it was a way of saying we can't be too doctrinal or doctrinal approaches to law are too narrow and they really don't, they're not very, they need more. And so my first instinct was nobody who does doctrinal constitutional law anymore. And then I thought, actually, they do. So we still get a steady stream in ICON of what I would think of as primarily doctrinal scholarship that's very good and that's worth publishing and that we publish. I was going to say, we tend to think, well, doctrinal work isn't ideas work, but neither is necessarily law and context or contextual, but they bring different things to the table. So I agree with many things that have been said, that it could be about looking at where law came from, as Monica said, the historical background too, or it might be how law travels, how law is applied, what happens when it hits the ground, when the rubber hits the road and so on. So it might be that, or it might be other things, how it's understood culturally, geographically, etc. I think it's kind of different from interdisciplinarity, but maybe that's a separate question. So we can leave that. But I do also understand it very broadly as scholarship that's not purely doctrinal. But I think it's worth talking about because there is still scholarship, as I'm saying, that's mainly doctrinal.
Yes. As we're talking, it gets. Lulu, please.
Yeah, I'll just chime in briefly, kind of based on building on what Gráinne has said and what others have already said. There is a sense in which I think constitutional scholarship has always been contextual, but there's just like kind of a question about like how much kind of context, right? So, I think about like when we teach our students about interpretation, of course, you always start with the text of, what you're interpreting, and then you read it in context, but then there's a debate about how much context, right? And so I think, a lot of the variation that we see in different approaches is kind of variation in how much context and what context that we pay attention to. And it's kind of, just a kind of point of question or kind of curiosity, and some of you might know the answer to this. I was wondering about the kind of origins of this, this idea of this distinctive form of contextual scholarship, given that we're, constitutional scholarship has always been concerned with the contextual in some way, and thought, maybe it's, perhaps it emerged in response to certain trends in scholarship. So, for example, work that's, overly formalistic or doctrinal, for example.
Roger or Leonard, do you have anything to add?
Hi, yeah, thank you, Tom. I was just going to, pick up on something that Lulu just said, which I agree with completely, which is, even even a short case note in the Law Quarterly Review will have a little bit of context about where that case came from, what its heritage was, and so on. And so, I think we're talking about a question of law in context being a question of degree in virtually everything that I read and that maybe we receive in public law. Just on the point of constitutional law in context versus interdisciplinary approaches to constitutional law. I think I can't speak for Aileen, of course, but I was slightly unpersuaded that there's a hard boundary between the two. Again, I think we're talking about a kind of a relative question here. Interdisciplinary approaches might be more self-consciously reliant on a specific discipline or comparative discipline, but contextual scholarship will often draw on literature from other disciplines as well, perhaps less self-consciously so.
As we're having the discussion, it occurs to me that there's different contexts for contextual scholarship. Like the intellectual trajectory here in the United States since legal realism in the 1930s has been to say, no, doctrine is nonsense in some sense. Of course, that's an overstated claim. But we then have had this explosion of interdisciplinary work now for decades and decades. And, other legal cultures or legal academic cultures don't have that same tradition, other journals and such as well. So maybe I can ask now, are you seeing any growth in this approach over time in your different journal contexts in terms of submissions in this regard? So the mode of calling
Tom,
on everybody is too hard. Yeah.
Oh, was the question about the growth in interdisciplinary scholarship or the growth in contextual work?
Well, again, it's an open question whether those things are different. But as you would define contextual work, what do you see?
Yeah, I do think that contextual and interdisciplinary are different. The contextual kind of goes to the what, and in some sense is inescapable, as I was just suggesting. So I don't really think of contextual as being a method. And I think as interdisciplinary is kind of going more to the how. So for example, I'm someone who's trained as a philosopher. My PhD's in philosophy, and there's a lot of theoretical work in constitutional law that uses philosophical methods that's not necessarily contextual, right? So contextual in some ways, I think some goes to kind of level of analysis and detail and kind of what's being considered besides the constitutional text and doctrine. But in terms of the journal, our journal is only 3 years old, so we're still a bit new. So to speak of trends in kind of publication is probably a bit premature. But we actually launched with 2 special issues, and our first special issue was actually on constitutional identities. And in some ways, the question of constitutional identities is a question about kind of it takes context seriously, it centers context. And so unsurprisingly, when I looked at that issue, pretty much I would say all of the contributions to that special issue, except for one, I think like 6 out of 7, or what I would describe as quite deeply contextual contributions. Our second special issue was on methodologies, actually, so which goes to the interdisciplinarity point and addressed kind of some of the issues with using, techniques of analysis that are developed in other kind of adjacent fields to law and their application to the study of constitutions. So I think that, over the 3 years that we have been running the journal, I think we've seen kind of a steady stream, both, I would say, in contextual articles, kind of broadly understood in the way that we've been talking about before. But I would also say that we've seen in kind of consistent submissions and a publication of articles that are quite consciously methodological, whether that's interdisciplinary or kind of thinking about how they are kind of approaching kind of the contextual materials that are informing whatever the research question is.
Excellent. Leonard, why don't I bring you in? Are you seeing any trend in this regard?
Perhaps I can say something about the specific kind of contexts which are relevant to our journal. It is very particular that we also look at how constitutional orders interact. So the Portuguese, in Portuguese, there is this wonderful concept of interconstitutionality. And so we are always looking for work which works in that context, on that type of issue and theme, which is, of course, a rather different context from the ones we've been mentioning now, because it's another legal context in which we place it. So it is, in a sense, more like comparative law, except that in the European context, the role of European Union law and European Convention of Human Rights in the national constitutional context, creates a separate type of, let's say, contextual studies, if I may call it that. And on the interdisciplinarity, in our editorial board, we have been trying to strengthen expertise on more empirical approaches, and we have had some manuscripts which we also published, which had for lawyers not very standard approach. But I can't say that the number of submissions we get is really increasing in that field, because we had one of those quite empirical studies already in one of our very first issues. And in general, I find it very difficult to say what the wave is, so to say, in which direction it goes. It is, of course, we don't publish very, 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 very many pages, which makes it already difficult to speak of a clear trend. On the other hand, I have noticed that in the kind of area where we want to publish, it is increasingly easy to get good copy submitted. So in that sense, I would say, yes, there is more coming on the there's more produced, which is specifically on those kind of contexts. Remains that even in that area of context, European context of national constitutions, national constitutional context, or European phenomena, even there, of course, it is very important to look at history, to look at culture, to look at political cultures, to look at constitutional cultures, judicial cultures, which all enter into the study of those issues. And they, in my perspective, I feel that this historical dimension has always been there. The state, the constitution is a particular historical thing. But the more political, social, economic contexts, that there is more and more an eye for, I would say.
Thank you. Gráinne, what trends are you seeing? You already mentioned that you are getting doctrinal pieces. So what's the direction in your journal?
Yeah, so I'd say, I'm going to maybe draw a distinction between contextual work, which I interpret very broadly along the lines that we were talking about. It doesn't necessarily require specialized methodologies, though it can, it's just looking at something different, and classical legal training or traditional legal training doesn't prevent people from doing certain kinds of contextual work. It doesn't, they don't need additional skills, but there are many kinds of contextual work that do require additional sort of skill sets. And so that's one thing is, pieces of research that involve particular kinds of empirical methodology, whether it's qualitative or quantitative or big N or whatever. You see legal scholars doing more of this. We're definitely seeing more sort of scholarship that looks at context in a way that requires new methods and new methodologies. Then we also see an increase in ICON in submissions from scholars from other disciplines. And I see that as a little bit different, but that is from historians, from political scientists, from sociologists, from philosophers. And I don't know if we want to talk about that now, but there's a distinctive set of issues that arises with evaluating those and thinking about them for the journal that's a bit different from evaluating scholarship from legal scholars who know who they're writing for and that they're writing about law, but they use methodologies they've been trained a little bit in, they've taken courses in, and so on. And I think we see a lot of both of these, actually. Legal scholars branching out with the methodologies they're using, having been trained in new kinds of methodologies that maybe some of us on the call, I'm probably amongst the ancients and wasn't trained in these, but many will have been. But increasingly, I think young legal scholars, academics are actually getting serious training in empirical methodologies and other kinds of approaches. It's not easy to do all of them well. Sociological approaches aren't easy to do well, anthropological and so on. So it is true that that's, it's an additional challenge for someone who's doing serious law in context or contextual constitutional, depending on how deeply they're going. But I would say we do get still a fair amount of traditional doctrinal, not very contextual or not very deeply contextual scholarship, but we also get scholarship using other methods from other disciplines, and we get scholarship from other disciplines as well.
Susan, what are you seeing?
Okay, so I am, full disclosure, I'm not a legal scholar by training. I'm a political scientist who was, I brought international law into my research, and it continues to be an important part of my research, as well as, how I teach. I teach an international law class from a political science perspective to master's students, for example. And our editorial team is very interdisciplinary, multidisciplinary. Like we have, a historian of political thought, we have political philosophers, we have, traditionally trained legal scholars, as well as international relations scholars. So I think that we are, at our inception, when we were founded, meant to be an interdisciplinary and multidisciplinary journal. But in addition, because we understand ourselves, like we've called ourselves global constitutionalism, we're sort of both making an argument, like in our, founding, that constitutionalism exists within a global context, right? And as well as within a national context. So I can't really speak to whether or not there's trends, right? But because I think that by the nature of our multidisciplinary, interdisciplinary origins and our focus, we do attract those kinds of manuscripts and submissions. And in addition, our editorial yearly try to set the stage for how like political, economic, and historical conditions that are rapidly changing, right? We've been around since 2012, and I was trying to think about what have been major developments that like shaped the context of constitutionalism since 2012, and I just gave up like after just thinking about the first few years. And that, is there even a global constitutionalism, like given all the attacks, right? These are things that I've been thinking about deeply in preparation for this event. And of course, we would argue yes, because it's not a perfect thing, and it doesn't constrain all behavior. And so I would argue that what we have sort of noticed is that we do get sort of individual case country studies, and we don't typically include them if they're not sort of deeply sort of thinking about how that national case study is engaging with global constitutional concerns, right? So it has to be a case study that's like comparative in its and contextual in its framing.
Very helpful. I'm just going to open up and see if anyone else wants to jump in on this question.
Can I say something about constitutional studies? As you probably know, constitutional studies is a new journal, or to be more precise, it's a relaunch of a previously existing journal. And I would say that this journal, this new era of constitutional studies, explicitly encourages contributions that are contextually sensitive and interdisciplinary. And you can see that in the very first sentence of the mission of the journal. I will read it for you so that you can realize that the dimension of what I am saying. It says, constitutional studies publishes work from a variety of disciplines addressing the theory and practice of constitutional government around the world. So in that sentence you can see both interdisciplinary approach and contextual approach to constitutional analysis. And well, we have just had one issue in this new era of constitutional studies. We have 9 articles in that issue, and I would say that all of them, the 9 articles, are highly contextual. And let me give you a couple of examples. There is an article on constitutionalism in Africa, which was written by Marcus Dockenforde, and this author emphasizes the importance of colonial legacies to explain constitutional developments in Africa. And the same with the article on Arab constitutionalism, which was written by Said al-Ali. He explains the impact of colonial and post-colonial rulers on the region's political culture and state institutions. And the same with the article on constitutionalism in Eastern Europe, an article written by Silvia Suteu. She explains, or she argues on the limits of institutional and normative analysis and design to explain constitutional developments in that region of the world, in Eastern Europe. She says if there is hope of a return to constitutional government in several Eastern European governments, we have to go beyond normative and institutional analysis, and we have to introduce political and cultural changes in society in order to have a return to constitutional governments in that region of the world.
Thank you. Roger.
Hi, yeah, I could, perhaps I could come in from the perspective of a slightly older journal, and then maybe hand over to Aileen, who could say something about some of our recent observations and trends in submissions. I mean, in one sense, a contextual examination of public law is in the nature of UK public law. I mean, the nature of the UK Constitution, I guess, requires engagement with constitutional practice as a source of rules, as a means by which rules might be amended, as a means of reflecting on the effectiveness of a particular rule. It's kind of in the nature of the beast that a contextual assessment of one degree or another is required. But also in terms of academic patterns, I mean, there's long been also a functionalist school in UK constitutional thought. This is reflected in Public Law as a Journal. John Griffith, a member of that functionalist school, which kind of took government as the start point rather than legal doctrine as the start point of a public law investigation, was of course the first editor of Public Law. And the journal's coverage has, since its inception, long included elements of the discipline which lend themselves to contextual discussion, conventional aspects of the Constitution, ombudsman, administrative justice, that kind of thing. So yeah, we've had a long track record, I think, of contextual discussions. But I mean, potentially that may have changed. And if I can hand over to Aileen, she might be able to tell you why.
Thanks. Yeah, so as Roger said, this is a long-standing feature of the journal, and unfortunately I didn't have time to go right back to 1956 and kind of analyse what we published. I did have a look at what we published over the last 5 years since Roger and I took over, and over that period, more than half of the pieces we published have been, I think, contextual, broadly understood, and there's been maybe a slight increase over time in the percentage of contextual versus doctrinal or theoretical pieces we're we've been publishing. I think sort of standing back from my role as journal editor, and maybe this is a bit anecdotal, but it seems to me that there was a bit of a decline in UK constitutional public law scholarship around about 2000, more interest in doctrines because we suddenly had lots of new doctrinal schemes to talk about, a definite theoretical turn. And you would hear people lamenting when they were trying to appoint in public law that, you know, the new PhDs that were coming through, everybody was doing constitutional theory, nobody was doing tribunals or kind of functional administrative law. I think what we could say is that that's not true anymore. So we are definitely seeing quite noticeable amounts of contextual work, and particularly empirical work, not just in those kind of traditional areas where we might have expected it, tribunals, immigration, social security, all of that kind of stuff, but we're seeing empirical methods being applied in new ways and in new contexts. And one thing that has really kind of leapt out for us is a new focus on treating case law not purely as a source of doctrine, but as a kind of empirical data source in and of itself. So we're seeing kind of interest in systematic review of cases, people trying to understand who's bringing cases to court, what kind of cases they're bringing, what the outcomes are, and the outcomes not just in terms of did they win or lose the case, but what might be the kind of broader implications of litigation. So there is that sort of, I think there is that empirical turn. It's still quite a small proportion of our, of the material that we're publishing overall, but there is a noticeable trend, and particularly amongst younger scholars, to be doing the kind of empirical work that Gráinne was talking about. And as I say, in new contexts. And we're also sort of seeing some interesting work on constitutional culture, constitutional identity being done from an empirical perspective as well.
Monica, no obligation, but you want to add anything?
No, I'm agreeing with most of what I hear, but just to say that, so if you think of contextuality as levels, so levels of contextualism in legal writing, I think, so there still is the stream of doctrinal work that is submitted to us, but always with context in it, right? So it doesn't make as Gráinne also said in the beginning, I think we have gotten used to that, so to have some context, but then more and more, I think that there are more levels, deeper levels of context involved now in legal writing. And I think it is reflected not only in the fact that we have some, not large streams, but some new methods being used also by lawyers or co-authored between lawyers and non-lawyers using new methods, but also approaches and new theories and new approaches. So for instance, critical approaches to law, understanding what is beyond the law, I think is something that is novel. In addition to some more empirical work than before, more historical work and law and approaches like law and literature, law and law and economics approaches. So it's not just the methods but also the theories and the perspectives and the approaches to the study of law, I think, where we see some new trends.
Monica, let me stay with you. I mean, so how do you assess these papers as they come through? Is that a challenge? And relatedly, do you see any mistakes, common mistakes that this kind of work is, generating when it's submitted?
Okay, good questions. So on the mistakes, I find that very difficult. I think, so what we do take into account is that our readership mostly consists of constitutional lawyers and European lawyers. So it has to be understandable for them So that also means for us as well. So that I think is the main criterion. And then to have it peer reviewed. So as Leonard also indicated, in the composition of the editorial board, we have made sure that we cover broader fields. So also new methodologies, new perspectives we have added over the past years in the editorial board. And that helps us to find peer reviewers. That is absolutely very helpful, so that we find the peer reviewers to review this newer type of work that we ourselves may not be so familiar with.
Mm-hmm. Gráinne, could you answer that question?
Yeah. So if I take somehow it's a little bit easier with the approaches that Monica was talking about. If we're thinking about scholarship that that isn't so mainly doctrinally focused, but is taking a critical look or some other kind of perspective or approach, I think we generally feel that we can evaluate. But when it comes to the more sophisticated methodologies, I think there are two problems. One is that of, well, maybe three parts almost. One is the editorial team itself evaluating them. The other is finding specialized, or at least methodologically sophisticated reviewers. And it's hard enough to find reviewers. We all know that, right? How hard it is to find peer reviewers these days who'll accept, but finding the right ones. And Tom is a frequent victim of this on the empirical methodology front for ICON. But also the readership, thinking about, will this piece work? And that's a difficult one because it's a bit chicken and egg. You say, well, our readers are mostly constitutional lawyers, they're not empiricists. And then you think, but, the field is changing and we want the field to change and we want our readership to change and so on. So you have to think about that also. So what I think we try and do is, we don't within our team at the moment have, because it's a small team, great methodological pluralism and variety. And so we do have to, when we get a piece that's, relies very much on its methodology and that it's beyond our immediate expertise, we have to think really carefully about the reviewers to find at least one and maybe two that focus predominantly on the methodology, and then one or two that do what we in the team will be doing, which is reading it. Is the idea interesting? Is it comprehensible? Does it feel additional, novel, etc., to to the literature that exists? And that is a more familiar sort of task. But bringing those two together, really being sure that this methodology is done properly, done well, and sustains the claims that are made. But then also how to make sure the piece is not just readable but interesting for others, because there's a tendency, and it's not all, certainly not in all scholarship that uses different other disciplinary methodologies, but there's a tendency that for the methodology to take up a huge amount of space in the paper, and that really doesn't work, we find. So we struggle with that, where there's a few paragraphs at the beginning, a few pages at the end, and then the rest is the graphs and or the maths. And that doesn't work. So we try and figure that out, that, where is the methodology going to go? Is there a way of putting it in an annex, in a link, and something? And then what's the paper without it, or with only a small amount that summarizes it, and so on. So I think that's a big challenge. Not all contextual work, gets into that problem, but contextual work that's relying on data, that's relying on empirical methodologies, and that's relying especially on novel and specialized forms of methodology, they do raise those issues of reviewing and readership accessibility, I think.
Excellent. Lulu, any comment here?
Sure. I think the experiences that have been described by Monica and Gráinne largely reflect the experiences that we've had. I think the kind of the audience issue and the expertise issue are kind of the two main things that we have to grapple with. So, we welcome interdisciplinary work, but it does need to be something that is self-consciously oriented towards a legal audience. And we have published very successful examples of that. So I was just thinking, for example, at our most recent, I have a prop with me, our general issue 3.1, Owen Caroline, Sylvia Gagliardi, and Daniela Rodriguez Gutierrez did a great piece on investigating constitutional culture. which explores the use of focus group methods in exploring constitutional culture. And I think what's really successful about that, I mean, these are legal scholars, but they also know something about these sociological methods and are able to kind of translate that for a legal audience and kind of make the case for its use in the legal context. But we do sometimes get submissions that, I mean, frankly, are not really communicating to a legal audience, and then we have to think really carefully about whether that's appropriate for the journal. And sometimes it's not. So that's the audience concern. And then I think with the peer review, that's so far, and again, it's early days. We're only on our third year of the journal. It's early days. So far, we've been very, very fortunate to have a pool of referees who have the requisite expertise, and we do often do what Gráinne suggested. So you need someone who has the requisite expertise in that field, but then you also need some generalists who are able to evaluate it from the perspective of a law audience and whether it makes sense to someone who is perhaps working on a similar topic, but with different set of training. I think one of the biggest concerns here is, and this is why the expertise of the referees is really important, is that sometimes there's a worry that a scholarship of a particular kind gets sort of passed off as doing excellent work within that discipline, but without meeting those disciplinary standards if you don't have a referee who's available, who is across basically a member of that discipline. So again, concrete examples, since I'm trained as a philosopher, so someone who is basically has submitted something that's essentially some type of debate in philosophy, but it's sent to a law journal, and then we send it to law reviewers who it's not meeting the kind of disciplinary standards of philosophy. That creates a real challenge, I think.
Susan, anything to add?
Yeah, so like the others have mentioned, we recently changed out a significant number of people in our editorial board. We want to do that every X number of years, not only so we can have a fresh pool of reviewers, but also we wanted to bring a lot more younger folks in, people who are less than 10 years out from their PhD, who had been doing innovative work. And so that was something we did last year. I think it's really helped us with our pool and helped us with our orientation. In terms of a common mistake, I think that when it comes to contextual work, sometimes some of the submissions we get can be a little bit inductive, someone's really fascinated with something and they want to write about it, right? So they're empirically oriented with a problem or a puzzle, but they're not necessarily theoretically engaged enough. So they might make certain claims that our reviewers do not like. And we've had these situations where, the desk editor was like, well, this is a really interesting and important topic, but because that person was, maybe they're not trained in legal methods or other forms of sort of legal analysis, they maybe made some claims because their training was a little bit self-taught that our reviewers really didn't like. So working with those kinds of manuscripts, helping them catch up with, your conceptual framework isn't particularly strong. You're not necessarily clarifying which literatures and debates in this field you're speaking to. That's been probably the biggest mistake. And I also find that I tend to be more oh, this is so fascinating. And I love these empirical puzzles because, they're compelling, but that is a challenge.
Very interesting. Anything to add, Roger, José María?
Yeah, just an additional challenge for constitutional studies that has to do with its multilingual policy. We intend to accept submissions in many different languages, in Arabic, in Mandarin, in Spanish, in English, in French, in Russian. So that means that we will have to find reviewers who are able to review articles written in in those languages. So that's a real big challenge for this review. And in the future, we will also aim to accept submissions in even more languages. If you read the policy of the review, the intention is to accept even articles in Japanese, in Croatian, in Danish, in Dutch. That's a huge challenge, and we will have to find people who are able to make those the reviews in those languages.
So, Roger, I don't know if you want to say anything.
I mean, I wouldn't really add a great deal to what's already been said. I mean, one of the challenges for us in this regard is, as has already been mentioned, ensuring that our editorial committee, in one sense, has a range of kind of subject-specific expertise, has methodological experience, and in the UK, kind of in our specific public law context, sometimes also has the institutional experience that we're looking for. So at the moment, we have members of the judiciary sitting on our editorial board. We're looking to hopefully gain some representation from amongst the legislatures of the UK and so on in due course. I mean, beyond that, I mean, sometimes I don't think that sometimes I think that the problems that we have with material in a kind of a law in context sense are the same kind of problems that we see in pieces of work that are purely doctrinal. I mean, they could be poorly presented, they could be unpersuasive, they could be kind of lack grounding in the literature. These are problems which are kind of endemic rather than, I think, limited to a particular type of scholarship.
Terrific. I want to remind the audience that we are going to have some time for Q&A. I have a couple more questions, but if you have your own questions, you can pop them in the Q&A function, and we'll channel those through to the panel after we're done with the main discussion. So Jose Maria brought up this approach of really maximally contextual approach to scholarship is where you're publishing scholarship in multiple languages, because we all know languages are ontologies, they're universes, and when you're in one, you're not in another. And I think that's really interesting. I mean, one of the things in our discussion is a kind of a theme here is contextual versus comparative, I think. If you think about large N statistical work as being really just making a lot of assumptions about comparability across contexts, contextual work, at least on one version of it, is the opposite. It's one where you really have to go very deep into that legal culture, that legal system, in order to understand what's going on. So I guess the question I want to pose to the panel is, to what extent does contextualism actually lead to tension with the comparative in comparative constitutional law? Because it's very hard to compare context. Every context is unique. So I wonder if I can ask the panel to speak to that.
I'm happy
Aileen, why
to
don't
jump in.
Oh,
sorry.
Yeah,
Is that okay?
I was going to start with Aileen because I didn't ask her the last time. So please, Aileen.
Thanks. I mean, I take the point that you're making, that the kind of more depth you need in one jurisdiction it's going to, from a purely practical point of view, it's going to be very, very difficult to replicate that across multiple systems. However, you could make the point that contextual approaches, on the one hand, guard against naive use of comparison. You might also say that sometimes a kind of comparative understanding, a broad comparative understanding, is sort of part of the context. In other words, not assuming that what's happening in your particular jurisdiction is unique, and nobody else has ever done it before. So I think from our point of view, we don't really see them as necessarily completely at odds, but inevitably it's going to be hard to do both a very thorough comparison and a very, very contextual approach, simply because words are always limited, people's capacities are always limited.
Lulu.
Sorry for jumping in out of turn.
No.
I was just in reflecting on the question that you posed, Tom. I was thinking that, maybe to some extent, whether or not we see these things in tension turns on our views about scholarship. And if we see kind of the wider discipline as kind of a, form of kind of collaboration between people who are doing different kinds of work, then they're both kind of, complementary and necessary forms of scholarship that advance our knowledge in different ways. I think, one of the challenges with the highly detailed contextual work is, kind of thinking about, well, at least this is something that we've been thinking about in our journal is, how, other kind of publication formats that, which is, and this is related to the question about methods as well, that can, not necessarily research articles, but we're working on kind of this idea of kind of commentaries and symposia of commentaries on a particular set of issues. So again, example from our recent general issue, we have a symposium on Mexico's constitutional demise and context, which consists of, several shorter pieces that are written by people from Mexico with, experience and kind of insights that are drawn together in different ways. And we think, that kind of, scholarship can form the foundation of other types of scholarly work, and that those complement some of the other types of kind of more overtly comparative work. For the purpose of our journal, we take a pretty wide view about what counts as comparative. So single jurisdiction studies that are, oriented towards a more of a global audience and explaining, something that's happening in that jurisdiction that might be of wider kind of interest that then can help kind of inform more overtly, explicitly comparative work, I think is something that we welcome.
Yeah, that's very helpful. Jose Maria, maybe I'll turn to you, not just because Lulu mentioned Mexico, but also because because of the approach that you brought up of bringing together, getting very deeply into context through languages. How do you think does this undermine the comparative, I guess, is the question.
I would say, Tom, not everything is comparable. When you do comparative work, you have to be aware of this. But you can compare constitutional developments in countries that have similar contexts. You can do comparisons, I don't know, between Brazil, Mexico, and Argentina to analyze their presidential systems, for example, or federalism in these three countries. But maybe you could not make a comparison between, I don't know, constitutional developments in federalism in Germany and in Mexico. So maybe you could, but the contexts are so different that comparisons could be without meaning or without results in terms of research or fruitful research and analysis. So you have to be careful what you can compare and what you cannot compare. When you take context into account, you can compare countries or constitutional developments in countries that have similar contexts.
Yes, thank you. Monica, do you want to add anything?
Just to say that I'm not sure that I see that there is a tension between contextualism and comparative work, only to say that it only makes comparative work more challenging, right? So comparative work, if it is well done, is contextual. I mean, this is because that will help you understand whether or not a comparison can be made, etc., and what we can draw from the comparison. So comparative work has to be contextual. Now, possibly or probably, since we have become more used to deeper contextual research, even in national constitutional research, that also means that comparative work has become more difficult to do it well. So in that sense, you could say that there is a tension, but I think that the two go hand in hand, right? So good comparative work is contextual and helps, the two help each other, but they do make the focus on more context does make it more difficult to do good comparative work, which may be one of the reasons why we see less of that in our journal. So over the past years, of course, that is also because we have this special focus on the European Union and on the Council of Europe and the interrelationship between legal systems, but the pure comparative constitutional work, we see less of that, and that may have to do with the fact that it has become more challenging to do very good, solid comparative work.
Mm-hmm. Susan, you want to jump in?
Yeah, so I agree with the sentiment expressed here that they don't have to be in like conflict. So because we sort of think of the global constitutional order as a context, I do think it's, good comparative work can be done thinking about the global constitutional context, right? And we kind of define that as, human rights, democracy, and rule of law, and, potentially like progressive development. And so, for example, one of the kinds of work that's been done recently is comparing countries where there have been democratic elections of sort of I don't want to call them, but like executives who engage in overreach and kind of push the limits of their national constitution. So, coming from the US, I feel this very distinctly. So like countries like the Philippines or Brazil under Bolsonaro or the US under Trump, right? So these are very different countries, very different constitutional contexts, but operating within this global constitutional context. And they've been very fruitful and interesting.
Gráinne, let me see if you have anything to add.
Sure. I mean, I'm just with a very interesting discussion. I'm reflecting on it. I agree with the starting point that there's no not even there's no necessary tension between them, but obviously purely comparative work without context would be very odd, very thin, but also the other is true, that purely contextual work without a comparison, at least for ICON, I suspect for many of the other journals, we struggle with that one a lot, which is what about when you have a really deep, rich study of a provision and its background and everything, and you're thinking, but it's a jurisdiction that's maybe not so familiar, so that's good, but there's always this sense of, shouldn't it say something to the broader readership rather than just be a country study or a jurisdiction study and so on. I think we come down sometimes different places on that depending on the piece, but in general, there is a question. All good work for a journal like ICON in principle should have a comparative or a lessons for, kind of dimension, as well as something more than, I think, something more than purely doctrinal. It's always, when we say that, you think, well, what would be purely doctrinal? Like you want to have some context, not just what the provision says and some kind of very lawyerly analysis of that provision, but something that tells you about how it came to be and what its implications are, how it's received and so on. But I think the deeper the context, the more challenging it is to do comparison well. But I take comparison also, honestly, in a broad sense, in the way that I was saying, and not every piece has to have jurisdiction X, Y, and Z, and looking at them all. A piece could be comparative in that it's reflecting on the possibilities and problems and so on of a particular kind of constitutional set of provisions in different places, even if it's studying mainly one jurisdiction. So I hope that's responsive.
Very helpful. Roger, I don't know if you want to add anything. I've got something actually to add. So some years ago, I published in the American Journal of Comparative Law a piece called Studying Japanese Law Because It's There. And my claim was that partly that we can study foreign jurisdictions on their own terms without any instrumental rationale, even a comparative instrumental rationale, that it's knowledge for its own sake is valuable. But I think I was also making the point that if you're studying some foreign jurisdiction, there's always an implicit comparative work that's going on between the audience and that jurisdiction. So if you're studying something that's very, seems to be very obscure or something like that, comparison, the reader is comparing. That's what we do when we are outside of a jurisdiction. And so that's another way to think about the inherently comparative work that gets done when we have scholarship that's taking law in context. Well, this has been excellent panel discussion so far. I think I want to turn over now to the Q&A portion of the session. And for that, I'm going to turn it over to David, who will beam in here.
Okay. Yeah, thanks, Tom. So we have a few questions from the audience, and if there's any additional, please feel free to add them. So I'll turn to the first question. So the first question deals with kind of the discussion around peer review, and largely building on what José María mentioned about kind of diverse languages. The question centers on kind of to what extent kind of there is an attempt to bring in diverse reviewers, particularly from diverse backgrounds, diverse kind of parts of the world. So those working in kind of Asian jurisdictions, African jurisdictions, or quote unquote global South kind of jurisdictions. So if anybody wants to jump in here.
I'm happy to.
Oh, sorry.
You go ahead.
Okay.
Oh,
I'll just speak very. Oh,
I'll
sorry.
tell you what, I'll pop in here and be the moderator. So why don't we start with José María and then Lulu?
I just want to say that Constitutional Studies is a project linked to the International Association of Constitutional Law, which is a global organization and which has links with constitutional scholars from every region of the world. So we will take advantage of that organization, and also, of course, of the Constitution project, constitutional. Your project, Tom. I don't remember exactly the name. It's the Comparative Constitutions Project, where we'll take advantage of all the organizations and all the scholars that form part of Tom's project and of the International Association of Constitutional Law in order to find the right reviewers to do the job. So it's really challenging, but it can be done because we have the networks and we have the contacts.
Lulu, please.
Sorry for jumping in again. Yeah, no, it's a really interesting question. When we do often think about when we're selecting reviewers for a particular article, trying to bring in people who have different perspectives. It's slightly different than the question that the audience member asked, but we often think someone who's going to love this and someone who's going to be really skeptical of it, because we want to bring in different perspectives like that usually. So diversity is often an important consideration when we're selecting referees.
Anyone else want to chime in on this?
Can I was going to say something, if that's okay.
Please, Aileen.
Yeah, so I mean, as has already been said, our starting point is to find the most appropriate reviewer for the piece. If it deals with a particular jurisdiction, we would look for somebody who has knowledge of that jurisdiction. That may be somebody who's based in that jurisdiction, or it may be, or it may be somebody based elsewhere, but who has relevant expertise. We will also use non-lawyers where that is appropriate. And that can be very helpful in some circumstances. Sometimes those non-law reviewers are more nervous about reviewing for us than we are having them review for us. They kind of sometimes think that there's something something mysterious and esoteric about reviewing for a law journal. But I don't think we particularly see it like that. So it is always who is the best person, taking account of subject matter, jurisdiction, methods, all of those things that are relevant. And we're not limited to our editorial committee at all. We use them where appropriate, but we go outside.
David, why don't we go on to the next question? And what I would say to the panelists, why don't you use the hand-raising function, and then I'll call on you in order as David asks the questions. That's the easiest way. Should have figured this out an hour and a half ago, but here I am. David, next question, please.
Sounds good. Yes. So there's a question kind of centering on basically the extent to which kind of contextual work might be more or less relevant depending on the area of constitutional law that's being researched. So in particular, kind of whether or not contextual methods or contextual kind of approaches are less relevant to, for example, constitution building as opposed to other areas of constitutional law.
You've dazzled them. Lulu, please.
So I don't think there's a hand raising button on this, but it might just be like my lack of knowledge of how Teams works. So
but
sorry
you use the old-fashioned method. Perfectly.
Yeah, this old-fashioned hand. Yeah, so the question is, I guess, about whether there's certain areas about where kind of contextual materials are less or more relevant. My instinct is to say that a lot of it kind of depends on what your research question is and what your the aims are of the study. It's hard to kind of categorically rule something in or out. I mean, the example that was given is constitution building, and actually context seems really important to me for constitution building, but maybe the person who's asking the question was thinking about a particular research question that would make it less relevant.
Aileen, do you want to jump in? No. Okay. Anyone else? All right, let's go. Keep going, David.
Okay. There's an additional question that specifically, sorry, I'm trying to kind of, some of them are quite lengthy, so I'm trying to kind of sum them up. But the question basically kind of deals with the extent to which kind of there's preference specifically when dealing with kind of single jurisdictional studies, whether or not there's preference for kind of larger jurisdictions as opposed to smaller jurisdictions, whether or not that has any kind of influence.
Please, Gráinne.
So, that is something we think about a lot in terms of whether a single jurisdiction study, fits well and so on in the profile of the journal. And again, a little bit like, what Lulu and others have said about the previous question, it all depends, So, when you say, is there certain kinds of work where context is less important, really depends on your research question. And on this, I'd say it depends on what the paper, the study brings forth. And in general, we do have a kind of an inclination to think if there's a jurisdiction we don't hear much from or publish much from, we're really inclined to want to publish a paper by a scholar from that jurisdiction or from someone who knows that jurisdiction or can bring that knowledge forward in a very good way. So I think we would be inclined, if we have a single jurisdiction paper from a big usual suspects place, that's much less likely to be attractive to us unless there was some really fantastically interesting question. But there's always a baseline question with ICON of, does this bring, something interesting forward, but like what Tom said about Japan, but that's also speaks to the rest of the world and not just people who want to know, what happened in Japan, but rather something of interest to the global community more broadly of constitutional scholars. But I think there are times when a particular jurisdiction or particular set of jurisdictions where we haven't had much material from that's a thumb on the scale, I would say, when thinking about whether it makes it, through, because there's always a lot of material competing. But no, I mean, and it is true, yes, if we get a paper from the US and it's just sort of some issue of free speech in the US and it's interesting and all that, we might be a bit, if there's no effort made to draw in any kind of broader perspective, other jurisdictions, other reflections, and we get a lot of material from there on this topic, etc. So that's just to give you a sense of some of the parameters.
Anyone else? Yeah, that's an interesting question. Sort of I hear you saying, Gráinne, is there another outlet? Is there something that's distinct about this paper for our journal, or a US only paper there's a million journals for, so why should you publish it? I think that's really an important consideration, obviously, for journal editors. David, I think we're back to you.
Okay, we have a question about basically whether or not I guess as journal editors, there's concern regarding kind of the position of the academic researcher when they're conducting contextual studies. So, for example, in relation to their class or their cultural background, especially in multicultural countries where there may be no consensus, within different communities regarding certain areas of constitutional law. So, I guess whether or not kind of that is a matter of concern. I don't know the extent to which kind of one would know, but whether or not kind of that plays out in kind of your work.
Yeah, so the generic version is, how do you look for bias in the writing that might find itself manifesting? Who wants to answer that one? Susan, please.
Well, we had a particular instance where a case came, it was like a case in context, a national constitutional study, and we made sure to get country matter experts who were both experts in the country. And it was a country, like others have mentioned, that doesn't typically get written about in sort of global north constitutional journals, international law journals. So we've got, well-known scholars who are both from the country and study that country to be reviewers, and they found a bit of bias. So in the end, we didn't work with the paper. I think that recognizing, right, getting that diversity, whether it's, disciplinary diversity or other kinds of, diversities and approaches in your reviewers are kind of the best way you can deal with that potential for bias.
Anyone else? David?
We have a question. It's very specific, but I'll still put it to the group. That basically says, if a constitutional provision has fallen into long-term desuetude, should a contextual approach treat it as normatively dead, even if it remains textually valid?
Very specific. Lulu.
Yeah, it's very specific.
I'm calling on you.
I was just going to say, I think that sounds like a research question. I think the audience member should write a paper about it and submit it to our journal.
Sounds like it indeed. I think other than that, I'm trying to go through. But I think that covers all the most of the questions that we've received. Just trying to make sure that we've given everyone a shot.
By the way, I find the last question rather interesting, because we have what we find in our particular constitutional system, crazy as it is that sometimes these words, which maybe meant something or one thing in 1789 and then have never been invoked or looked at really for the subsequent 2 centuries, suddenly are coming back. And of course, it's partly a feature of originalism, and in which text is super important. So to me, this is one of these things where you just never know. You never know what features of a constitution are dead, what are fit to be revived given new political circumstances. Again, though, I think, as Lulu said, it's an excellent research question on which there's certainly no general answer that we know of yet.
Maybe they're not dead, they're undead.
Yes, zombie provisions. They come back. Back from the dead. I always think if we have this, the Third Amendment in our context, I'm afraid that might come back one day.
Well, on that note, I think it's a good place to close. Well, let me, of course, let me start by thanking Tom for moderating. It's been a really great discussion, and for managing the discussion. We'd also, of course, like to thank all of our presenters today for a really rich, and I'm sure everyone can agree, thought-provoking discussion. And of course, as always, thanks to everyone in our audience for joining us today, and for for raising really interesting questions. Just in case people are wondering, as always, a recording of the discussion will be uploaded to the CCC's YouTube channel shortly. So if you'd like to direct others to it, or if you want to re-review it, you'll be able to do so. Lastly, as always, we like to highlight some upcoming events. So I'm just going to pull up on the screen if I can. There we go. So in the new year, the center will be hosting a roundtable discussion on the new Cambridge University Press book by María van der Tol from the University of Cambridge, titled Constitutional Intolerance: The Fashioning of the Other in Europe's Constitutional Repertoires. And we have Fabio Wolkenstein from the University of Vienna and Warwick Senior Larson, who will be acting as discussants. So as always, for more information about this and all of our events, please check out our website or social media pages. So yeah, thanks very much to everyone for joining us, and depending on where you're joining us from, enjoy the rest of your day or evening. Thanks very much.